Hi everyone, Joe Gentili at Sarraf Gentile LLP. So today I want to talk about just a couple of tips that come up with naturalization problems. So my firm, we handle a lot of cases that have to do with issues that come up during naturalization. So usually that's in the form of a delay. Somebody's waiting a long time for an interview or for a decision, or there's a naturalization denial. Fortunately, we're able to help people in these situations frequently because there is separate law that deals with naturalization, where Congress has granted more rights to people that are having issues at the naturalization phase than they typically have at other parts of the immigration process. So we got more tools to work with at naturalization than we do at other phases of immigration. So the first tip is for delays. And the tip is that if you have a naturalization delay, like other types of delays with immigration, you could file a mandamus lawsuit. However, there's an additional law, an additional type of lawsuit that you could file with naturalization delays, and that's called a 1447B action. And what that does is if the government has given you your naturalization interview and 120 days have passed and you still haven't gotten a naturalization decision, you could sue under 1447B. And it's even more powerful than a mandamus lawsuit because under 1447B, there's a hard deadline in there of 120 days that you're entitled to a decision, and a judge can decide your naturalization case on their own without USCIS at that point. So it's a really powerful tool. If you haven't had an interview yet, if that's the delay that you're facing, you can't use a 1447B lawsuit, but you still have a mandamus lawsuit, which are also really successful in getting good results. So that's my tip for the day for delays. On the denial front, the good news is that under the law, you have an absolute right to sue in federal court if you have a denial at the naturalization phase. And like I said earlier, your rights there are stronger than for other types of immigration cases. So for a lot of other different types of immigration cases, if you have a USCIS denial, the court is going to review the USCIS's decision, the agency's decision, to see if there was an error, essentially, if their decision was arbitrary and capricious. So if it's kind of a close call and the judge disagrees with what the government did, the judge is still going to rule in the agency's favor in that instance. You really have to show that there was essentially a mistake of some kind. With challenging a naturalization denial, though, the judge decides the case what's called de novo, from new. So the judge does not have to give any deference at all to what USCIS decided, and a judge can decide your case and award you citizenship based off the judge's interpretation of your case. They don't have to say USCIS made a mistake in the denial. They have a de novo review. So one thing to keep in mind with that, though, is that before you get to go to a judge and make that argument, in most places, I think the proper move is you have to file an N336, which is essentially like an administrative appeal to USCIS. And if you get a denial there again, then you're able to go to a judge and deal with that ability to have a judge decide your case de novo. So those are my tips for the day. That's one for naturalization delays and another for naturalization denials. So as always, I hope you enjoyed this. And if you find any value in this, please subscribe. And if you have any questions, feel free to reach out. Thank you. Bye.